Welcome to Literary and Jury Charge Practice. Let's get started with a little jury charge warm-up. Gotta find my watch. And we will, this is a rather short jury charge, but again, it'll get your fingers moving. Ready? Here we go. In determining the effect, weight, and value of the evidence that is presented before you, the law does not permit you to act in an arbitrary manner, but requires that you carefully consider all of the evidence and give to such evidence that weight to which, when measured by your reason and experience, it is entitled. A person is qualified to testify as an expert if he has special knowledge, skill, experience, training, or education sufficient to qualify him as an expert on the subject to which his testimony relates. Duly qualified experts may give their opinions on questions in controversy at a trial. To assist you in deciding such questions, you may consider the opinion of the expert who testifies with the reasons given for it, if any, by the expert who gives the opinion. In examining an expert witness, counsel may propound to him a type of question known in the law as a hypothetical question. In such a hypothetical question, the witness is asked to assume a set of facts to be true, and then to give an opinion based on that assumption. In permitting such a question, the court does not rule and does not necessarily find that all the assumed facts have been proved. It only determines that those assumed facts are within the probable or possible range of the evidence. It is for you, the jury, to find from all the evidence whether or not the facts assumed in a hypothetical question have been proved, and if you should find that any assumption in such a question has not been proved, you are to determine the effect of that failure of proof on the value and weight of the expert opinion based on the assumed facts. Now we will try a short literary and this literary is called, sorry about that, Congressional, and it's short. Again, just for some warm-up. Ready? Here we go. Mr. Chairman, it is a privilege to say a few words about the work that is being done by this group and to recommend inclusion in the bill of the amendment which was made by the senator from Vermont. When I first realized that I had the ambition to go into government service, the senator from Vermont was the very first person from whom I sought advice. Once upon a time, my colleague was an isolationist, as were many others on this side of the chamber. However, we came to realize, as others have, that the United States can no longer live in a vacuum. Although in his early days he thought that America could be an island, he has realized that that is no longer true. Isolationism is no longer a viable policy. Both Republicans and Democrats in the United States Senate today are pressing for enactment of this bill and the amendments which have been offered this morning. The funds necessary have already been appropriated, and the appropriation will take us to the point where the United States can look beyond its borders and become a part of the world order and give leadership to that order. It will be able to take responsibility and to shoulder its fair share of the financial cost of this project. Mr. Chairman, I would hope that the vote will be unanimous for the bill and its amendments. Now back to some jury charge. Ready? In other words, you apply to each one of these witnesses who have appeared here, including the defendant, the same rules which you would apply in your business affairs in arriving at a conclusion whether a man has told you the truth, that is, within your province entirely. Of course, we start out in every case with the presumption that every witness who takes the stand will state the truth, that is, before he takes the stand. However, this presumption that the witness is going to tell the truth may be negative or may be overcome by what transpires after he has taken the stand. It may be negatived or it may be overcome by the character of the testimony that the witness may give, or by contradictory evidence, or by the motives of the witness. Finally, any matter in general which you contend reasonably sheds light upon the credibility of the witness may be considered by you. A witness willfully false in any material part of his testimony is to be distrusted in others. The jury may reject the whole testimony of a witness who has willfully sworn falsely as to a material point. If you are convinced that a witness has stated what was untrue as to a material point, not as the result of mistake or inadvertence, but willfully and with a design to deceive, then you may treat all of his testimony with distrust and suspicion, and reject all, unless you shall be convinced that he has in other particulars sworn to the truth. In this case, the defendant has offered himself as a witness and has testified before you. Having done so, you should weigh the testimony of the defendant by the same rules you would weigh the testimony of any other witness, but you should keep in mind that he is the defendant and of course has a vital interest in the outcome of this trial. You may consider his hopes and fears and what he has to gain or lose as a result of the verdict. Here for some literary practice. This is an article in the JCR, the Journal of Court Reporting, and it is called You've Got This. Ready? How many times have I heard "you've got this"? During the 13 attempts it took me to finally pass the California Certified Shorthand Reporter examination, many on Facebook or on the cheap and sleazy side, an online court reporting newsletter, read my narrative about my journey through court reporting school. For those of you who didn't, I would like to inspire you to never give up on your dreams. I started theory in 1984. I eventually had to quit day school. I found a full-time job and I went to night school for about 10 years, during which I made no progress. Furthermore, I had some mean-spirited bosses whom I allowed to make my life miserable. I had about 4 surgeries, which meant I had to take time off from school. As my grandmother aged, she became very ill, and my family and I spent many hours in the emergency room. I had several car problems and was involved in a couple of hit-and-run accidents. I was very close to my grandmother, who passed away, and later, around 2002, both my mom and brother were diagnosed with cancer. My brother died in 2003. After my mom died in 2004, my husband, James, helped me go to day school full-time. I will always remember what he said. I want to make it so that the only thing you have to do is go to school. I did very well in day school. I maintained a 4.0 GPA. I was the recipient of the 2004 Academic Excellence Award, and I was a member of the International Honor Society. I was on a mission. Just before I was eligible for qualifiers, my husband suffered a stroke, and later he had to have a total hip replacement. James has recuperated, but he still has some health challenges. I took my first CSR in 2008. I was excited. Unfortunately, there were many more vicissitudes of life, but I believed if I wanted it badly enough, I must stick with it. Vicissitudes. That's one to put on your list of problem words, possibly. Vicissitudes. All right, well, we will finish that article up later. Now let's get back to some jury charge practice. And this jury charge is called income tax evasion. Ready? There is a distinction between the civil liability of a defendant and criminal liability. This is a criminal case. The defendant is charged under the law with the commission of a crime, and the fact that he has or has not settled the civil liability for the payment of taxes claimed to be due the United States is not to be considered by you in determining the issues in this case. Each count sets forth a separate and distinct offense, and you must consider the evidence applicable to each alleged offense as though it were the only accusation before you for consideration. You must state your finding as to each count uninfluenced by the mere fact that your verdict as to any other count or counts is in favor of or against the defendant. He may be convicted or acquitted upon any or all of the offenses charged, depending upon the evidence and the weight you give it under the court's instructions. It requires a unanimous vote of all 12 jurors to convict or acquit the defendant upon each count. In arriving at a verdict in this case, the subject of penalty or punishment is not to be discussed or considered by you, and must not in any way affect your decision as to the innocence or guilt of the defendant. It is not the function of the jury to determine whether a defendant should or should not be punished for any conduct. It is solely the function of the jury to determine whether a defendant is or is not guilty of the charges set forth in the indictment. The jury is composed of 12 people. While undoubtedly their verdicts should represent the opinions of each individual juror, it by no means follows that opinions may not be changed by conference in the jury room. The very object of the jury system is to secure unanimity by comparison of views and by arguments among the jurors themselves. Each juror should listen with a disposition to be convinced to the opinions and arguments of the others. It is not intended that a juror should go to the jury room with a fixed determination that the verdict should represent his opinion of the case at that moment, nor is it intended that he should close his ears to the arguments of other jurors who are equally honest and intelligent with him. As jurors, you are expected to use, in the determination of this case, the same common sense that you use in your everyday affairs. We are trying in this court the case of the United States of America versus Martin C. Fisher, and no other case. The only issue before you is whether the defendant in this case is or is not guilty of the offenses alleged in the indictment. The title of this literary is called Accident Investigation. Accident Investigation. Ready? I was assigned to the accident in question on March 17. When I got to the place where it had happened, I noticed skid marks that extended for some distance, and then I saw what appeared to be gouge marks. I noticed that the gouge marks were approximately 315 feet away from the curb and at the curb itself. We measured them at the time, but I don't recall their length or anything. They appeared to be very fresh, and they were over toward the right-hand side of the street. In other words, it would be in the area that would be traveled by traffic that was going west. The gouge marks at the curb were actually areas where small pieces of concrete had been gouged out on the top portion of the curb. It is my opinion that these gouge marks were caused by areas where the vehicle struck the surface of the roadway and then hit the curb. The vehicle was totally demolished. The front of the vehicle had taken a very large impact, a very strong impact. It appeared as if the car had gone off the cliff on its nose and then rolled over on its top. The top of the vehicle was totally demolished. The final impact, I believe, was in the area of about 100 feet from the base of the cliff, and then the vehicle struck and flipped over from there, so it was approximately 100 or 120 feet. The car was going at a very high rate of speed. As I recall, the vehicle did not touch the ground or the dirt area, or make any tire prints within the area, which was a distance of approximately 20 feet before going over the cliff. The fact that it went through a secure barrier made of steel cable and posts would also indicate that it was going at a very high rate of speed before it went off the road. It is my opinion that the excessive speed was the primary cause of this accident and the resulting damages. All right, back to some jury charge. Ready? If you can conscientiously do so, you are expected to agree upon a verdict. You should freely consult with one another in the jury room. If any of you should be convinced that your views of the case are erroneous, do not be stubborn and do not hesitate to abandon your own view under such circumstances. On the other hand, it is entirely proper to adhere to your own view if, after a full exchange of ideas, you still believe that you are right. You will bear in mind that you are here for the purpose of trying issues of fact that are presented by the allegations in the indictment filed by the grand jury and the defendant's pleas thereto. You should perform your duty uninfluenced by pity for the defendant or by passion or prejudice on account of the nature of the charges against him. You are to be governed, therefore, solely by the evidence introduced in this trial and the law as given you by the court. The law will not permit jurors to be governed by mere sentiment, conjecture, sympathy, passion, or prejudice. The importance of your duty requires that you consider the right of the people of the United States to have the laws properly executed, and that it is on you citizens selected from this district that finally rests the duty of determining the guilt or innocence of those accused of crime. And that will conclude our literary and jury charge practice.